1.2 Preventive Detention. So before getting into the topic, we'll just know about the preventive detention. So the concept of preventive detention was taken from the British rule. In India, during the British rule, they used this preventive detention as a weapon against Indians to control freedom movements. But at present, even in today's situation, the preventive detention is used in India. We know the effects of preventive detention. All our fundamental rights like freedom of speech, expression, right to life and liberty, all those will be lost. So the concept of preventive detention is mentioned under the Article 22 of the Constitution. So let's look into look into this box first. The constitutional safeguards against the preventive detention. So Article 22 generally is states that protection from arrest and detention, and Article 22 clause 1 provides that no person can be arrested without notice, and he has the right to consult and be defended by the legal practitioner. And Article 22 clause 2 says that a person who is arrested should be produced before magistrate within 24 hours, and if he cannot be kept in the custody beyond 24 hours without the magistrate's permission. Article 22 clause 3 states that the above two laws, that is 22 clause 1 and 22 clause 2, will not be applicable in case of preventive detention. Now here, what is preventive detention? The word itself says prevent future offences. To prevent the future offences, a person is arrested. So we'll discuss about it in detail after finishing these articles. So now Article 22 clause 4 says that a person who is in preventive detention should not be in jail for more than 3 months. But if advisory board decides and confirms a person to be in preventive detention, then it will be extended for more than 3 months. Remember here, they should take advisory board permission. So if this permits to keep the person for more than 3 months, then they'll keep. Or else, see here, Article 22 clause 7 clause B is also same. Here replace with parliamentary laws. So here also Article 22 clause 7 clause B says that if Parliament bylaw states that the person to be kept under preventive detention, then also it can be extended for more than 3 months without the consent of advisory board. So if a person who is under preventive detention, if the government want that person to be for more than 3 months, then it should take the permission of the advisory board, or under Article 22 clause 4, or the Parliament bylaw should provide maximum period for such detention under Article 22 clause 7 clause B. So these are about the article which deal with the preventive detention. Now coming to the main topic, the preventive detention is in news because Supreme Court said to use preventive detention only in exceptional circumstances. Now carefully observe the first statement. Supreme Court has ruled that preventive detention to be used only in exceptional circumstances. The reason why Supreme Court said like this was because according to the National Record Bureau, yes, over here, look at this here. So according to National Crime Record Bureau report, which is Crimes in India report 2021, over 1.1 lakh people were placed under preventive detention only in 2021. Only in 1 year, 1.1 lakh people were placed under preventive detention. And the other fact is, here. So here 78.33% of all detention orders under National Security Act from 2018 to 2020 were incorrect. Now, as per these records, we can come to a conclusion that center and state governments are excessively using this power to suppress the fundamental rights of the people of India. So, under the Constitution, 7th schedule, center can use preventive detention only in matters of defense, foreign affairs, security of India, while the state government, under the same schedule and list 3, it can use preventive detention on matters of public order, security of the state, maintenance of essential services. So, only on these grounds, the center and state government can use preventive detention. So, let's look into the some of the important cases which are related to the preventive detention. So, the first is Ashok Kumar versus Delhi administration case, 1982. So here the Supreme Court stated that the objective of preventive detention is not to punish a man for having done something before, but to prevent him from doing offense in future. And then I'll only take the important Supreme Court judgments. And here the Shambhunath Shankar versus State of West Bengal case. So, in this case, the Supreme Court stated that the preventive detention infringes the fundamental rights guaranteed in the Constitution. But for the security of the country, sometimes it is necessary to take extreme steps. So, as per Shambhunath Shankar versus State of West Bengal, whatever the Supreme Court has said, it was true. But when we see the records, 1.1 lakh people have been arrested under preventive detention, and 78.33 of cases are fake. So we can clearly state that they are excessively using it. It is not a problem if under this Shambhunath Shankar versus State of West Bengal, the Supreme Court said for the protection of the country we can use preventive detention, but this has been overused or misused by the state and central governments. So some laws which permit preventive detention there are also many laws which permit preventive detention. So we'll see. So the laws which permit preventive detention first is Code of Criminal Procedure and Narcotic Drugs and Psychotropic Substance Act 1985. So here see Code of Criminal Procedure. So yes, this law can permit preventive detention. And next, Narcotic Drugs and Psychotropic Substances Act. Under this also a person can be under preventive detention. And Unlawful Activities Prevention Act, under this also preventive detention is applicable. Foreign Exchange and Prevention of Smuggling Activities Act 1974. Terrorist and Disruptive Activities Prevention Act 1985. Prevention of Terrorism Act 2002. So under all these acts, the preventive detention is applicable. Now coming to the way forward, so these are all about the brief thing about the preventive detention. Now we'll directly go to the way forward. So the way forward here is the person who is kept under preventive detention must have the right to consult or legal representation should be provided for him. So as per the records, we got it 78.33% of them are under preventive detention. All are fake. So if those persons are provided a legal representative, he cannot be victimized, and judiciary works at his own level, at their own level. Next is the advisory board, which is mentioned under Article 22 Clause 4. We have said, so if a person under preventive detention should be extended for more than 3 months, then we have to have the permission of the advisory board. So this advisory board has the power to extend preventive detention for more than 3 months. So that advisory board should have a sitting judges of High Court for the speedy trial and fair decision making. And next is, an independent body should be established to inquire on the allegations made upon the preventive detention. And the preventive detention must also have constitutional safeguards under Article 21 and 22 by providing safeguards against arbitrary arrest and detention.